Hi, so today we will cover strict liability and absolute liability as far as needed for CLAT and other law entrance examinations. So coming to strict liability, it can be called an extension of nuisance, and it is also known as low no fault liability, as the defendant can be held liable due to no negligence of his own. Please pay attention at the year mentioned, as it can be asked in the legal knowledge section. And also note these words highlighted because they are very important for the definition. These are the elements that are needed for a case of strict liability. While strictly legal definition may not be important, the three elements are extremely important to understand for the legal reasoning questions. Please keep in mind that the note mentioned here is not a thumb rule to go by, but as far as CLAT questions and other entrances go, mostly questions are framed from the last two elements. For example, they might mention that they might in the facts they might mention that there is no escape of the dangerous thing, or a natural use of the land may be underway. So please pay attention to them. Do not misread or ignore crucial but small words in the facts, as these elements depend on them and the answer changes accordingly. Moving on, uh, these are the defenses that are available to anyone against a strict liability rule. There are certain exceptions to the rule which can be used as defenses. The tricky questions are made from this part of the concept. The first one, plaintiff's own fault. It is self-explanatory and directly linked and in fact opposite to the second element of the rule. Secondly, the act of God, or also known as vis major. Pay attention at the keywords for this one and reduce the time consumed per legal reasoning question. And also, just by seeing words like heavy rains or sudden storm, don't jump to the answer, as everything is not unforeseeable. You will see an example of this ahead. It was present in the 2014 paper. Lastly, statutory authority. It is the only absolute defense. So this covers up the major concepts for strict liability. Please pause the video and go through certain keywords that are needed to answer the questions correctly. Now coming to absolute liability, we can call it stricter than strict liability. The biggest difference from the previous rule is in fact that it is an enterprise which works for profit. This rule was laid down in the MC Mehta case, and Google both this and the Union Carbide case for the respective years, as they can be important for legal knowledge. Please do note again the highlighted portions, and that there are no defenses available, none at all, to the person in charge. Going through some questions all from past year papers. Please pause the video and read the principle and facts and then see the answer. All are pretty straightforward questions. So this is another 2007 question, and even if you're confused, to go with the answer which provides at least some amount of reasoning, which only option C evidently does, as all others just state what should be done, and option D is actually totally out of the scope of the principle. If you have any doubts, you can please post them on the comments. This is another easy question, in fact based on the MC Mehta case of CLAD 2013. This principle in fact defines absolute liability without expressly using the term. This is another way to confuse the examinees and throw them off guard. If you remember even a little bit of theory, you can do this question within seconds. So any form of movement outside the defendant's land counts as an escape, and thus liability is possible. Do note, as a matter of fact, that like 90% of the questions from torts, this one is also based on a real case called Crowhurst versus Amersham Burial Board. This is in no way important or needed or expected of you to remember, but the point being that there is no need to get worked up about the tort questions, as there are fixed number of cases which are at most given with little variations every year. So you just have to pay attention to certain words and most importantly do all past year papers. This is the question I mentioned while explaining Act of God defense. It's another easy and direct question. If at any time during a legal reasoning question you get confused or swayed, always use the elimination method where you can eliminate at least two options which are out of the scope or can in no way be the answer. Then you're left with two. Then either you can guess or go with the hunch. Like in this case, you see option C, which is totally outside the scope of the principle because it is mentioning an inevitable accident, which is nowhere mentioned in the principle. This is actually a case of absolute liability. So don't use legal knowledge or any outside knowledge when you're answering these questions. So now, as you can see, strict and absolute liability, though important topics, have easy and direct questions. Wherever variations or tricky questions are possible, they've been highlighted. Please do note them. As is evident, maximum one question is given from these topics per year, so we can at most expect two if the pattern is to change. Thank you and keep looking forward for more such videos by Law School 101.